When Chief Justice Roberts testified in his confirmation hearings, he was very deferential to the Congress. Not so, I might add, when he decided the voting rights case. But when he appeared here 3 years ago, he said this, and it's worth reading. I appreciate very much the differences in institutional competence between the judiciary and the Congress when it comes to basic questions of fact-finding, development of a record, and also the authority to make the policy decisions about how to act on the basis of a particular record. It's not just disagreement over a record, it's a question of whose job it is to make a determination based on the record. As a judge, you may have the beginning to transgress into the area of making a law is when you are in a position of reevaluating legislative findings because that doesn't look like a judicial function. Now, that's about as deferential as you can be when you're a nominee. But when Chief Justice Roberts presided over the voting rights case, he sounded very, very different. My question to you is, do you agree with what Chief Justice Roberts said when he was just Judge Roberts, that it's an area of making laws to transgress into what Congress has done by way of finding the facts?
I would find it difficult to agree with someone else's words. I can tell you how much I understand the deference that Congress is owed, and I can point to you at least to 2 cases, and there are many, many more, that shows how much I value the fact that we are courts that must give deference to Congress in the fields that are within its constitutional power.
Well, do you agree with Chief Justice Roberts? I sent you that quotation a long time ago and told you I'd ask you about it. Do you agree with him or not?
I agree to the extent that one's talking about the deference that Congress is owed. I can't speak for what he intended to say by that. I can
well, not what he
what
intended to say, what he did say.
Now, I heard what he said, sir, but I don't know what he intended in that description. I do know what I can say, which is that I do understand the importance to Congress's factual findings, that my cases and my approach in my cases reflect that. I've had any number of cases where the question was deference to congressional findings, and I have upheld statutes because of that deference.
Is there anything the Senate or Congress can do if a nominee says one thing, seated at that table, and does something exactly the opposite once they walk across the street?
That, in fact, is one of the beauties of our constitutional system, which is that we do have a separation of...
Beauty in the eyes of the beholder. It's only Constitution Avenue there.
Well, the only advantage you have in my case is that I have a 17-year record that I think demonstrates how I approach the law and the deference with which, or the deference I give to the other branches of government.
I think your record is exemplary, Judge Sotomayor, exemplary. I'm not commenting about your answers, but your record is exemplary. Let me, and you'll be judged more on your record than on your answers, Judge Sotomayor. And for those who are uninitiated, your preparation appropriately is very careful. They call them murder boards at the White House. I don't know what you did, and I'm not asking. We've had a lot of commentary, and you studied the questions, and you studied the record, and your qualifications as a witness is terrific in accordance with the precedents. You're following the precedents there very closely.